Hi, everybody. It's right on time, so we are going to get started. You know how these things go. We got to start with the title slide and the introduction, so there'll be a little bit of time for folks to get on board without missing any essentials. My name is Rachel Armstrong. Thanks for coming today. You're in the session Leasing Land, Legal and Practical Tips for Success. Hopefully everybody's in the right place. If this isn't what you expected, you should still stick around because I think it's going to be interesting. You might like it. So here we go. Who am I? Rachel Armstrong, joining you from northern Minnesota. This is where I grew up on an old farm, basically from the time that the land was taken from Native Americans was given to my family. You can see this is cut over territory where loggers came through first, farmers came in after that. My family wasn't thrilled about farming. I think they had dreams of making it big in some other area, but farming is what it was. By the time I came around, I actually liked farming and thought it would be pretty cool to be a farmer when I grew up. That career path didn't quite work out, but agriculture has been my entire life since then. In my mid-20s, I started to look around and think, how am I really going to make an impact in farming? What's right for me? How can I serve the community that I love? As I looked around, I thought, there seems to be a lack of legal information. We're making decisions. We're not quite sure what the legal implications are. Maybe I should do that. So I did. Enrolled in law school, went to the University of Denver, Stern College of Law. And on my commute on the bus every day to law school, I looked at these mountains and thought, yeah, how am I gonna do this? What exactly is my plan to bring legal education to the farming community? Law school is 3 years long, so that gave me enough time to put together a program. By the time I graduated, I'd managed to secure funding, and Farm Commons is the result. I'm the executive director today. I'm back in northern Minnesota. These are my little preschool munchkins, and I have to start with an apology that we cannot continue to the normal 4 o'clock Central time frame. We have to move our 30-minute question and answer session to tomorrow because these being COVID times, I have to run and get my kids. Preschool's closing. So I'm gonna go do that, and then we will be back to answer your questions. But we also take a lot of questions today. We'll get to that. Farm Commons serves farmers and ranchers nationwide. Wherever you are, we have resources for you. I'll be talking about things that are at our website right now. Go there, get acquainted, but also know that it will change in March 2020. We're completely reformatting our website. The content will be live rather than in downloadable PDFs, so it's going to be a better experience. Enough about me. I want to know about you. Please introduce yourself by using the chat box. If you've been on Zoom in these COVID times, you've probably used the chat box before. If you don't see it, click the 3 dots that are down at the bottom in gray and select the chat feature there, and it should pop up for you. Please type in there a sentence that summarizes 3 things. 1, your name. 2, if you have an affiliation, like a farm or a business or nonprofit. And then I want you to say what you're an expert in. You might be thinking, I'm not an expert, I'm a generalist. Oh, but you are. You're an expert. So tell us what that thing is that you do really well. Here's my example. I'm Rachel Armstrong from Farm Commons, and I'm an expert in getting 3 preschoolers dressed for winter and out the door to play in 15 minutes or less. Sometimes that's still too short of an amount of time, but I can strive. So let us know what you're really good at. In a few minutes, Taylor is going to help me summarize some of what you're talking about in the chat box. We won't be able to read everyone's introduction, but we want to get a little bit of a flavor of who's with us. But before we get there, Taylor, I forgot to have you introduce yourself. Can you tell us a little bit about who you are and your role at Farm Commons?
Sure. Hi, everyone. I'm Taylor. I'm the coordinator at Farm Commons. I do work for legal research, our volunteer pro bono program. I do office management. So I do a little bit of everything when something is needed. I'll be here kind of moderating the chat for your introductions, some of your questions, and some of the little tidbits Rachel will ask you for a little bit later. I don't have a whole lot of background in farming, but my background is mainly from law school and environmental. Um, but it'll be really nice to see everything that goes on today. See you in a bit.
Yeah, Taylor joins us from Hawaii, so we are all over the place. All right, Farm Commons' mission is to empower farmers to understand and solve their business law issues within an ecosystem of support. How do we do that? With this, we create and deliver farm law education materials and workshops. We also train farmers to lead solutions in their own communities. So good stuff. A little bit more preparatory material. You have figured out how to use the chat box. That is fabulous. Use it for questions, because never mind, we don't have a Q&A feature in this one. So the chat box is your source of questions. I also have a couple of points where I want to discuss something, or I want to hear some stories. Taylor is going to help manage that. What I'm going to do is I'm going to ask you to raise your hand. Use the raise hand function. Should be a button that you are able to find on your control bar. That will send a signal that Taylor can see that you've raised your hand. At that point, Taylor can have you unmute yourself. She can allow you to unmute yourself, and you can tell us your story, your tidbit, whatever it is. Lord knows we don't want to hear me talk the entire time. So we have these ways to get you to talk too. So look for that. Taylor, what do we got in the chat box for introductions?
Got quite a few. It's really nice. So we've got, let's see, we've got lots of soil health. We have Mark from New Mexico. We have people from the EPA doing some soil health. Hi, Brian. Let's see, we've got land trusts in Washington and Oregon on farmland preservation. Hi, Alexandra. Let's see. Some of these are kind of funny. We've got Casey, an expert in relationships, and she works for Ward Labs in France Farms. We've got Willard Heck on Weaver Ranch, an expert at keeping track of details. That's always super important. Let's see. We have the director of strategy, and Harley Cross solves problems with the Land Corps. So there's quite a different range of group here. It's kind of exciting.
I love these areas of expertises. I see jack of all trades. I see expert in Daniel Tiger. Boy, am I as well. Solving problems. Perfect. These are exactly the skills that you need to be really good at leasing relationships. What you're going to find out today. Farm law education can reduce risk, build stronger communities, and create joy. Yes, even joy. Now, why? That's because it's really built around relationships. So, you are the right people to be here today. Legal education is so important to making sure that we build strong communities. But the research actually says you don't care about that. The research says that humans change when they are afraid, not when they have the promise of good things, but the threat of bad things. So I do have to pull in a little threat of bad things. 51% of farmers and ranchers are vulnerable to losing their lease within a year. That's pretty scary. Most of the folks that we know, agriculturalists across the United States, depend on leased land. When those leases are vulnerable to being lost or forces outside of their control, it creates tremendous vulnerability for the economic viability of that farm. The good news is we can fix this. And the other good news is that we don't necessarily need to know more laws. Yes, I am here to teach you laws, and we will talk about them, but you will also learn that stronger relationships are every bit as important to resolving these legal vulnerabilities as knowing the law. So we'll show you why, and by the end, hopefully you are lounging happily next to a water trough, because that would be great. Okay, launching into our basics. So we did send out a video for you to be able to watch beforehand. Through the power of internet, I know that about 6 people watched that. So that's not quite enough for me to really rely on you to know what was said in there. So I'm going to review it. Now, if you were one of those 6 people that watched it, thank you so much. I hope that this is still able to reinforce those points for you. I'm going to start with a story about Farmer Sam. So Farmer Sam was growing seed garlic as a way to raise capital for his own vegetable farm. In the fall, he puts $30,000 worth of seed garlic in the ground, ready to harvest the next summer. This land was leased. And of course, later that year, in late November, Sam gets a call from his landlord. The landlord says, "Hey, I'm in the process of putting the land up for sale. Want you to know I'm not renewing your lease come spring." Sam panics. Of course, this money of his is in the ground. Is he going to be left without any access to the land or to that incredibly valuable crop that he had planted? He's panicking, so he calls Farm Commons. He assumes that we have answers about what the law is going to define as fair in this situation. Reality is a little bit different, though. The first thing I had to say to Sam was, okay, Sam, what was your agreement with the landlord? What did the both of you agree to do when your relationship was coming up for renewal each year? How do you think Sam answered that question? He said, "We didn't talk about it. We didn't necessarily have an agreement. It hadn't come up. We just, we're not really working, we're operating in our own little world, but we didn't know this would happen." What does that mean? That means Sam is vulnerable to default state laws. The good news, the surprising thing to many farmers is that the first source of authority for what is fair in a situation like this is not state law. It is actually the agreement of the farmer and the landowner. That is the first thing that the law wants to honor. Only if farmer and landowner do not come up with their own agreement does state law kick in to define what is fair. So this is bad news for Sam because the default state laws are written for your very average general producer. Certainly, it's not going to be written for garlic producers. Many in your Western states, it's going to be written more for a livestock perspective. And that's going to be great for people who do livestock, but it's not if you're not. Where the state law feels that we mostly have annual crops, it's certainly going to treat that as a summer annual, not something that overwinters. So this is a dark story for Sam. He did not have much ground to stand on, but there's a silver lining for all of us. Farmers and ranchers have power. We have the power to create agreements that can suit our operations, and we can see those agreements protected in court. What we have to do is take the time to craft solutions that really will work for us. So this is a theme that we're going to be coming back to throughout our time together. If you don't have a plan, the state has one for you, and you might not like it. So make your own plan. Just to review our high points, state law on land leasing is a backstop for when farmers, ranchers, and their landlords don't come up with their own agreements. Resiliency is in having that discussion about the particulars of your arrangement. So, but what about Sam? Here he is, this desperate fellow who's in a pretty bad situation. For Sam now, what he needs to do right away is talk with an attorney. Once you're in a bad situation like that, the only thing you can do is start to work out the details of what state law really is going to provide for your exact situation. This is a bummer because this will cost Sam time and it will cost him money. At some point, the time and money needed to recover is going to exceed the value of the crop. And certainly it's eating into that capital he was raising to start his own farm immediately. The other thing I need you to know is that state default laws are not a panacea in almost all circumstances. They are not going to be neat and easy to execute. We'll get into this when we look at some state models. For this presentation, I've later on you'll see I've chosen to discuss California, Oregon, and Montana. The registrants for this course for this workshop come from a huge variety of Western states. And so I tried to pick 3 that were reasonably different in terms of how they treat the law and your typical agriculturalist who is in that state. So we'll get to some of the complications soon about relying on state law. Moving forward, though, we're going to remember that knowing more laws doesn't necessarily make us more resilient because we've already gotten into a problem. Preventing issues from ever happening is where true resilience is found. This means conversations. This means talking with your farmer, rancher, or landowner about the particulars of your operation. So next, what I'm going to do is run through several subjects that you should discuss in detail and explore about your relationship. Who, where, when. These things seem really obvious, but I need to encourage you to go into detail. Is our landowner actually a trust or an LLC? Precisely what land are we talking about and when? Are there limitations on the premises use? Presumably this is for agriculture, but does that mean we can make on-farm sales or do agritourism? Are we defining this as only animal agriculture, non-animal? If it's animal, can we slaughter? Do we have access to infrastructure, facilities, improvements, all of these things? When does the relationship end? Can we renew it? When? How? Can we terminate it early? How are we resolving issues and of course payment? There's a lot packed into these questions. Answers can be easy to come by, and we'll have an activity later on where we explore how easy answers are not necessarily what you're looking for. You're looking for thorough answers. But let's keep going with our list. If we're talking animal operations, we want to go into detail about species, breed, number of head. Can we have bulls? Stocking limitations on grazing areas, gates that need to be kept closed, fences for repair or maintenance. Do we need proof of vaccination? I include things like that because oftentimes you're going to have zoning regulations or other land use regulations that require that animals be vaccinated. And those rules can hold both landowner and the producer responsible for that. So any landowner wanting to cover his or her bases is going to also want to obligate the producer by way of the lease to satisfy those requirements. Your breachy animals that are constantly getting out, when is enough enough? ATVs, horses, trucks, when, where? Specialty crop operations are another story. Okay, so we can grow stuff. What stuff can we grow? Annuals, perennials, woody stock. What about weedy crops? Water is always of the utmost importance, and certainly with specialty crops, we have to talk about it from a couple of different angles. Water for irrigation, but then also water for washing. Increasingly, your wash water is going to be held to different standards than your water for irrigation, for food safety. So can we meet those standards? What about effluent and wastewater control? So packing and cleaning areas, storage. So I can store my tractor or my tiller, but what about my fuel? Sometimes insurance policies have things to say about where fuel is going to be stored. Whoever is holding that insurance policy wants to make sure that those nuances are related back to the producer. Forage operations. Here we're getting into weed management and soil fertility issues to protect the value of this product for production. Weed management also ties us into other county and state laws. Who has to manage the weeds, when, and how? That was a big, long list. And what I want to hear from you in another minute or two is whether you are talking about these things with your landlord/tenant. Do these things seem relevant to you? Have you heard about or encountered issues like these already in your leasing relationships? I have one more thing to say, and then I want to get back to the chat box where you may have entered material there, but also do raise your hand if you are willing to pipe up and tell us verbally what some of your experience has been with these questions. Before we get to that, you might be thinking, this is a weird way to start a legal conversation. We're talking about conversations. When does she tell us to write this down and get a written lease? We will get to that, but I really want to emphasize the point that right now, talk is not cheap. Talk is extremely important for these questions. Can you find a lease online that answers all of these things? Maybe you can. Maybe you can, but that's not your lease, and that's not your relationship or your dialogue with the farmer, the rancher, or the tenant. These things, we are better off when we engage in conversation. I'm going to give you a story. So we have farmer rancher A. Farmer rancher A went into their relationship thinking, hey, we're going to do it right. We're going to go to the internet. We're going to get a lease. We're going to sign it. So they do just that. They find something at, say, aglease101.com, and they download, a livestock lease. I have these things right on my desktop, books full of leases. They go get one, they sign it, and they walk off thinking they're good. They have done their duty. Farmer and rancher B, they decide they're going to do things right too, but instead they sit down and they have a really long conversation about all the things that they want to do on the land and see happen. They spent 3 hours, discussing different production mechanisms and stocking rates and where the cattle are going to be marketed and all those kinds of things. At the end of the conversation, they don't write anything down though. When the well pump breaks, who do you think is probably in a better position to deal with that problem? Probably farmer and landowner B, because they have a better relationship. They talked and understood each other more fully and may be able to handle that issue. Farmer and landowner A are going to this document that they may not have read thoroughly, trying to figure out what it tells them they're supposed to be doing. They didn't write it for themselves. So I'm going to say to you right away, invest in the relationship. Yes, we will get to writing it down, but first invest in that conversation and an understanding of what someone is trying to do on your land or what the landowner wants to happen, and where you both are at. But quickly to your thoughts and reflections. Taylor, do we have any hands raised or stories ready for the telling?
So far, no, but I reposted the question to give them a better idea of what we're looking for. But so
Wonderful.
far.
Yep. So as we go forward, if you want to tell us if you are already having these kinds of conversations or stories about when you didn't and things went wrong, we're interested. Any questions thus far? Or should I move on?
I think you can move on.
Let's talk about when things go wrong. So despite this happy picture I've painted where, rancher and landowner B have this great conversation, sometimes things do still go wrong, of course. It wasn't something they talked about, or it was so serious that it still disrupted that relationship. We do still need to write things down because things do inevitably go wrong to a deeper degree, and we have to anticipate bad things. Putting things in writing serves a lot of purposes. Number one, it helps us preserve our memory. The older I get, the more I can't remember what I said yesterday. And so that's, of course, we write it down so we can remember, we have something to look at. The process of writing things down also helps us create clarity. When we speak verbally, allow ourselves less clarity because, we hem and we haw, and just our verbal tics allow us to roll over things that we're not certain how we're saying. Once we sit down with a pen and a paper, we are forced to really say what we mean and to avoid going and that's very helpful. That is a really good thing. Creating clarity also emerges when we pass that written word back and forth. When you and I are sitting over a cup of coffee, it's also really easy for me to blow past the fact that I'm not quite sure what you're saying, because it would be kind of embarrassing if for me to stop and say, I don't get you. I don't understand that. It's sort of confrontational. So sometimes we need to move to paper to continue to advance the clarity of the discussion that we're having. Last but not least, yes, putting things in writing is essential if you want to be able to rely on enforcement of that document. Now, in real life, rare is the farmer, rancher, or landowner that will actually enforce it. Most folks just prefer to hate each other forever rather than to go to court over a lease, but sometimes you still want to protect that ability. It can give you confidence, knowing that what you've got is enforceable in court if push comes to shove. So these are many very good reasons to put things in writing. They're not all legal. You need to do this for yourself so that you really know what you're talking about. The other thing I need to recommend is that you avoid unnecessary vulnerability from the start. Whether you're the landowner or the producer, think about where your vulnerability is and how serious it is to you. As a landowner, you may be relying on rental income to help fund your retirement, to help put food on your table. That's a level of vulnerability that might necessitate that you see an attorney and make sure it's enforceable and that you have full understanding of it. Similarly, if you are a beginning farmer and you are about to, quit your job and sell everything and move, let's get it in writing and let's make sure we know exactly what we're doing. Or don't avoid becoming that vulnerable so that you can avoid creating something bulletproof. If bad things still happen, see an attorney. You need to see an attorney as soon as possible, especially when much is at stake. Time is important. We may have statutes of limitations. We may have evidence that we need to collect. So get to an attorney right away if you're in a bad situation. Know that small claims court can be available to you. How do you find an attorney if that is in the situation that you're in? First and foremost is ask around. Your peers are the best referrals. And when you approach an attorney, think of it like you're interviewing them. You're interviewing them to take the position of your attorney. Ask them how fees are structured. In what sort of increment do they charge? By 15-minute increments? Do they round up from 1 minute if you just make a quick call? You deserve to know that. It's your right to know those things. Talk with them about how and when they communicate. If they're really an email person and you're a phone person, try to come to some common ground and ask about their experience with farming. There's not a lot of attorneys out there that really understand farming in depth. You're better off if they have at least a cursory understanding or are based in a rural area or something like that. So going to be in a better situation. They can at least speak your language. Okay. So we're in this bad situation where you didn't take the advice to talk it through and write it down. Things are going wrong, and you're trying to figure out if you need to see an attorney. Let's talk about some default state rules that are going to kick in. We're talking about Pat and Jamie. So Pat has been leasing Jamie's farmland for 3 years now. It's verbal, and every year they just keep doing what they were doing before. Things seem to run from, spring to spring. Jamie pays Pat once a year, but Jamie decides that he or she wants to lease to a different farmer next spring. When does Jamie need to tell Pat that this relationship will not continue? It depends on what state you're in. And I have my models here, Oregon, Montana, and California. In Oregon, we have 60 days of notice. Montana just requires 1 month. California, again, 1 month. That sounds easy, right? Okay, 60 days from what? 1 month from what? From the end of the lease. When does the lease end? The lease ends 1 day before it began. So if it begins on January 1, it's going to end on December 31st. So maybe December 1st or November 30th, we need to let them know. But why January 1? I threw that out because it seems convenient. But in reality, it is really hard to tell when an agricultural lease starts. Usually what happens, let's take Pat and Jamie. Pat and Jamie met at a potluck 3 years ago. Jamie said, I've got some farmland. I hear you're looking to start a farm. This sounds great. You want to talk, or I've got, 300 acres that I'm looking for a new rancher to come on. Pat's like, hey, sounds great. Let's talk. What's your rate? They start talking about rates. It sounds good. Maybe a month later, Pat stops by and he says, this looks great. It's going to work for my needs. They talk money again. Maybe they confirm via email. 2 months go by. Maybe Pat's looking to put some things in the ground now or get ready for spring planting. Maybe he or she doesn't pay until 4 more months go by. You get where I'm going. I don't know when that lease started. We don't know when that lease started. So we don't know when it ended. So we don't know how many days when we really have to give notice by. Your conservative landowner is going to have to back up 30 to 60 days from the soonest possible date that lease could have been interpreted to have begun. At least when we have a written lease, we have a date, hopefully. or we at least have a time when the email was exchanged. So we have those excuses that give us these start dates. The point I'm really trying to make here is state law doesn't help. We're still struggling to match reality with what the rules are of farmland leasing. We have so much that we could argue about. And if we don't like each other now, if Pat and Jamie are fighting, they're going to find a lot to continue to fight about, even though they've now turned to state law. So yes, here's my point. We don't know when it began. Again, we're going to be asking you for any stories that you've had. What if Jamie dies, goes into bankruptcy, or sells the property? Okay, generally the lease is going to hold. This is very common across the United States, and I didn't iterate specifically for Oregon, California, and Montana that yes, it will still hold until the end of the lease year. Now, again, a new landowner is taking over was going to be like, hey, y'all, when did this lease start? I don't know when this lease started. So again, some of those problems are going to keep precipitating through the relationship. Improvements to the property. Let's say that Pat put up a series of hoop houses. What now? Let's say Pat gets only 30 days notice. Is he going to have to take those down? Does it get any longer? In each of our states, and this is also the general rule across the country, it depends on how permanent the fixture is. How exactly did we put up this hoop house? Did we put in a 6-foot deep concrete footing? So this is going to take some serious effort to move, or is this one of those like more movable style hoop houses? If it's not permanent, then it is Pat's to take before the expiration of the lease. But the more permanent it is, the more damage it causes to the land to remove it, the more these are likely to be Jamie's. And Jamie may have no legal obligation to pay for the improvement. This is a general rule, and to the extent that farmers and ranchers don't want this, they're going to have to specify something else in the lease beforehand. What about crops on the land? So say Pat, like Sam, planted garlic on October 5 and received notice of intent not to renew on October 29. Can Pat come back in July to get the garlic? California says that crops are personal property. So that would be like, you left a car behind on the property. Technically, how this is going to play out is that the landlord is going to end up having to compensate you for the value of that property. Oregon goes a little farther. It's more protective of the producer. And Oregon says that the tenant shall have free access to harvest crops sown by the tenant before they were given notice. So in that case, Pat's like, hey, see you in July and don't disturb my garlic crop. But that's not necessarily the case in Montana. A tenant has a right to harvest annual crops still growing at the end of tenancy. But I have suspected, and there's not a lot of case law to back me up on this, but where laws like Montana go to the point to say harvest annual crops, they really are meaning crops that don't go over the winter. And so I'm not sure that this law would hold for garlic because garlic is different. Now I could be wrong. We're going to have to fight about it. And that's what we don't want to do. We don't want to fight. So we just have to figure this stuff out ahead of time. My tales of woe, they have no end. If you don't have tales of woe, I do. I got one more. Well pump breaks. Is Jamie obligated to fix it so that Pat can continue producing his crop or growing her livestock? Boy, let's talk about it. Okay, in Montana, we're talking commercial landlords here. And that's something I need you to know right off the bat. When we're talking about farm and ranch-based leasing, this is generally going to be seen as a commercial relationship. Your residential tenancy laws are not going to apply. Sometimes even if you combine commercial with the residential, sometimes that can become entirely commercial and all residential protections are lost. So we're going to, when we're assuming, we're defaulting to commercial landlord-tenant law. In Montana, a commercial landlord is obligated to fix dilapidation, but not obligated to make repairs. Is the well pump dilapidation? Montana law says that dilapidation is when you are rendering, when a breakage renders the property unfit for the use for which it was leased. Is land without water unfit for the use for which it was leased? I don't know. We could dig into the case law and we will fight about it. Oregon and California are a little more straightforward. No, there's not an obligation for the landowner to fix that unless we specified in the lease. So I have lots of scenarios of how things can go bad. Those are a few examples of how Montana, Oregon, and California tend to treat those issues. You can pick out some trends from here. So if you're in Colorado, New Mexico, you can see some of where these trends might be headed for you. But also, should you rush out to look up the particular laws of your state? Yes, because it's fun. But no, if you're busy, because you don't need to do that. You need to talk with the landowner or the producer who is on the property to come up with what works for you. To the extent that understanding default state laws helps you to explore opportunity, helps you to develop your own creative thought about it, that can be really good. But you don't need to know it, just you don't have to be obligated to it. Your creativity is better than state law. Has this happened to you? Similar stories. And most importantly, reflecting on this, let's take a moment to think about where you can see the opportunity for clarity in your leasing relationships. If you wouldn't mind taking some time to write into the chat box, which of these elements of a lease are feeling meaningful to you? Which of these do you think, gosh, I could talk about that a little bit more? Or I heard a story where, that did go wrong for somebody. And of course, any general questions at this point. We're going to take a moment and a little quiet space to have some reflection. You all are a quiet audience, so I think I just need to give you a little bit more time.
Landcore is asking if there are any recommended templates.
Yes, so there are many templates that you can find for a lease. Before I tell you about them, I want to make clear that that templates are something that Farm Commons in particular handles judiciously. Templates are sweetly alluring. The answers, the promise of certainty. Do not be fooled. These templates were not written for you. They were written for every farmer and rancher. You have to use templates judiciously. Yes, they're a starting point. They're a place to prompt conversation. They should generate discussion. If you sign it and walk away, I don't think you're necessarily any better off than if you never signed it in the first place. Sure, you can enforce it, but you might not know what it says and it might not work for you. So that being said, let us use templates to prompt creative discussion and to give us a starting point. I have a slide with this title on it coming up, but I'm just going to hold it up to my screen. It is called The Rancher's Agricultural Leasing Handbook, subtitle Grazing, Hunting, and Livestock Leases. This is an exceptional resource on agricultural leasing with a strong Western focus to it, written by folks that I know in the farm law world who are just really good at what they do. There are several template leases in here, and not just that, the whole beginning part of the book really does walk you through the things you should be thinking about. This packet emphasizes far more the money mechanics. How are you going to structure payment? How are you going to arrive at a rental rate? It does not go into detail about some of the things that I talked about earlier. Water usage, equipment breakage, things like that. Another source that I can recommend is aglease101.com or .org, I forget. That's another great source for your standard lease templates. Now, once we get through some of your thoughts and comments here, I have a little activity where I'm going to show you a lease from Aglease 101, and I'm also going to show you how it's not quite adequate. to really solve problems. And you and I together, I'm going to use my pen to edit that thing and make it better, which you can do too.
Okay, great. Thank you. Lori is asking, if land is depleted and you'll be rebuilding the soil, it will take years. How easy or hard is it to get a lease lasting 10 plus years?
Right. Getting a lease that lasts 10 years is as easy as saying, would you like a lease for 10 years? And someone saying yes. That is, it is, there is nothing standing in the way of you in a long-term lease. Okay, I should have said nothing. The thing standing in the way is tradition. People just don't do it. You know, I was just talking about this in the context of Illinois, so forgive me this. So, not in your vicinity, but about 98% of leases in Illinois are for 1 to 2 years. It's highly unusual, but that is a real bummer. There is nothing wrong with a long-term lease legally. The longer you get, like into 25 years, 40, 99 years, yes, we do have some particular legal things we need to think about. Farm Commons has a resource for you, inspiration it's a workbook with the title of something along the lines of inspirations for drafting a long-term lease for agroforestry. We have emphasized agroforestry because that's often when we're talking about a crop that really doesn't yield maximum fruit, so to speak, for a good 40 years or so. So long time frames. You can do it. It's no problem. Check out that guide and you'll see there's a couple of picky little legal things to pay attention to.
Okay, great. We did have someone raising their hand. I believe it was Alex or Alexandra. Please feel free to raise your hand again and I'll unmute you. So until that happens, let's see. We have Pam saying she doesn't have a lease, but that might be an option in the future. So she's saying this is very helpful. Let's see. Matthew's wondering about thoughts on creating a lease that includes both rangeland and housing. Is it better to have a separate lease for each or combine them under the same lease?
Great question. So I see Alexandra. I'm going to unmute her and then I'll get to Matt's question.
Perfect.
Okay, thank you. Sorry, my question might be a little complex too, but Rachel, thanks so much for your presentation. So I actually work for a land trust and we hold conservation easements with landowners on farmland and agricultural working lands. Some of the landowners that we work with have leases and have tenants on these farmlands. And as we start to think a little bit more strategically about potential climate change impacts and just some other impacts to the lands that we hold easements on, we're starting to take a little bit more of an active approach in managing these lands and working with our landowners. I'm curious if you have any thoughts or perspectives on how third-party entities should be involved within a lease, and if it makes sense for, like the land trust that holds an easement on this particular land, if it makes sense for them to, review that lease so that helps inform our management strategies for that land. I don't know if that was too complex or maybe not relevant, but just sort of thinking about how we can plug into the conversation a bit more.
Right. I definitely understand what you're saying. So a couple of things that I can suggest. I really like that part about third-party entities, and I'm thinking really fast on that. But let me start with a couple of things. So one of the things I often recommend is that farmer, rancher, landowner, that they schedule quarterly meetings. This can seem, it's non-traditional. It can seem burdensome, like, I just want an annual lease. Can we deal with each other once and be done? Establishing a regular meeting schedule allows us to talk about things that are never pressing enough that we need to pick up the phone, but that do have a substantial impact on our relationship over time. Things like climate change, threat of wildfires. If you're going to sit down for a quarterly meeting, you'll be like, hey, how about the fires such and such? How is that affecting you? Where is your mind going, in terms of the resilience of your operation? You're creating that space for conversation to happen about things that you both care about. So I find it to be a really helpful practice over time, especially when you have more of a like an institutional level partner on one side, where decisions are made, there's more than one person who's talking about this, you have a nonprofit board or something like that. Keeping those lines of communication open and getting a better feel for where each of you are at is really helpful over time. So that sort of, think of that as not necessarily like a review process, but just a staying up to date process. The larger a land holding entity is, and the more people, more farmers and ranchers that it works with, the more we have to start to think about that like its own business. That landowning entity is a business that has clients. Farmers are the clients, ranchers are the clients, but we need to think about how are we understanding those clients' needs. Let's pretend we're a mall and we're selling retail space, it's not that different. Some of the basic mechanisms that we can start to use are streamlined ways to request a meeting, preparation, meeting agendas, things like that. I know it can seem overly formal, especially those who are in a landowning capacity. They're not in it to make money like your land trust, they're in it to do good work, but still adopting more of a business mindset and thinking about farmers and ranchers more as clients can help create some, I don't want to say formality, but can create some more thoroughness. We can be active in building good relationships and not just assume they will happen because we are good people. So to your question about third-party entities, there's roles for third-party entities in terms of creating nutrient management plans or sustainability plans. If we're talking about logging woodlots or some kind of resource extraction that goes along with agricultural production, there's absolutely a role for third-party entities there to say, okay, so and so is going to create the management plan for the XYZ, and we're going to be held to that management plan. And using a third-party entity to create that plan can help, if the institutional partner in particular is not an expert in generating management plans or managed woodlot plans, they're not going to be able to understand what the farmer or rancher is proposing. So tying in that expertise to create more objective plans that are followed, that can, I think that's a primary role that I've seen for third-party entities in leasing relationships. But there's also no reason why, as scale increases, we wouldn't start to see more property management style, where somebody is going out to check on things and helping to screen issues and find resolution. So that is a real hodgepodge potpourri of answers. I hope there were some tidbits in there that were useful.
Okay.
Great, thank you so much.
What you mentioned about the farm management and the management system, I think leans into a question someone had pretty decently. So I think I'll skip to that one if we still have time.
Absolutely.
Okay.
Yep.
Jacqueline is wondering, her organization is thinking about leasing out smaller parcels of a larger property that they have that we might soon own in term leases for beginning farmers. So she's wondering about recommendations for handling multiple leases for different tenants and then issues that come up with them. And I figured what you mentioned about property management might lead into that a little bit. So I figured it'd be hers.
Yeah, so this is a model that we see emerge across the country. People are often calling them incubator farms, where you are, doing a series of small leases to try to help farmers and ranchers get started. You are in luck. We have a guide at our website to leasing in an incubator farm context. I should say right now, everything at our website is free. You can go get it. You do have to create an account because we do need to know who you are. And so go get that. Some of the issues particular to incubator farms are trying to get some level of standardization because you're working with, multiple people. And then also sometimes we have shared equipment usage, shared usage of, water sources. And so we need to develop standards for use of equipment or standards for livestock that we otherwise we wouldn't need, because there's not that many of us, and we're not working so closely to each other. So the more people you have, the closer you're working, the more you need these supplemental materials like equipment handbooks, and times of the day when people can or cannot run loud machinery. So take a look at our incubator handbook, and I think that is going to get you some more ideas for how to handle those situations.
Okay, great. I skipped over Matthew, but before I do that, we have a couple questions asking about the handbook that you put up. I believe
Right.
it was the lease template or something of the like. They are all wondering what it's called, and I also in that vein, if it's available on our website.
I'm going to type it. I can't type and talk at the same time.
That's okay.
Ranchers Agricultural Leasing Handbook. Google it. I do it for you, but then you'd all see me Google because my screen would change. But take a look at that. It should pop right up. Great resource. And you're right. We skipped Matthew's question. Let me get to that. Matthew asked something about if you're mixing residential and commercial, should you do that? Depends what your priorities are. If your priorities are to protect your residents as the tenant, you want that separate. You want to draft 2 separate leases, one for your occupancy of that residence, one for your commercial utilization of the farmland. What you're doing by doing that is you're preserving your ability to rely on the increased protections of residential tenancy laws. So if the water doesn't come to the sink, you have a right to demand that it be fixed or not pay your rent. You have a right to notice for when you're going to be evicted, and a process for making that happen, and a chance to refute that process. So if you're looking to protect your residents, separate those. Oh, thank you for putting up that link. National Agricultural Law Center is a great home for that. They have a lot of good resources as well. So we can definitely, let's do 2 more questions, and then I'm going to jump back into the presentation if we have 2 more.
Yes, we do. It seems like one question that has somewhat of a prevalence in multiple is going to be about, I'll just read this one. How about that? It seems important in regenerative agriculture to be on the same page as the landowner if there are plans to flip the ground, increasing its soil quality. Is there a framework to propose compensation for such improvements? And there's a secondary question that's like, if we do that, are we getting compensated? And then, what are recommendation for practices to quantify those positive changes to the ground?
Absolutely. Okay. So this is what I touch on a lot in the latter part of my presentation here. And we're going to tackle this from a number of different angles. How is the rental rate being set? That's one way to tackle that issue. It doesn't even necessarily have to be about, am I compensating them for the increased input costs of implementing conservation measure A? Some of this just goes back to how are we defining how the rent is set, and how does the way we're setting the rent create different incentives for the producer to improve that land. So we're going to go into that a lot more in depth. Maybe that's a sign that I should move on. Do we have a different kind of question that I should take, or should I probably just get into that detail?
We do have one smaller question. It's a little more personal based. Where did it go? So it's just that it's a family tenant situation that's not clear on the replacement of a septic system. One feels they're responsible, the other one doesn't. Are there thoughts on that from a general perspective, since we don't know all the details?
Right. I mean, that actually may be an issue. Our first question may be, is this a commercial or is this a residential lease? And that is not necessarily an easy question to answer, and it is a subject for state law. So we need to know, honestly, you're probably going to have to talk with an attorney to figure out if you want to understand your legal obligation, go to an attorney, and the threshold question will be, is this commercial or is it residential, which may depend on several different factors. And only discussion will bear that out. And then you will find which laws apply, and then you will discover it. Answers maybe, maybe not.
Okay, sounds good. That was the last one so far, so you are free to move on.
Okay, awesome. So I have a little activity that I'm going to model here for you. Pat and Jamie, well pump breaks. Pat can't irrigate. Pat asks Jamie, Jamie's the landowner, to fix it. Jamie says he'll get to it next week. He doesn't do it. 2 weeks go by. Pat asks if he can fix it himself. Jamie says, okay, but you have to have a professional do it, not you. Pat doesn't know any professionals. Jamie recommends his cousin. He's a professional. Pat says his cousin is too expensive. Pat gets irritated. Pat does it himself, sends Jamie a bill for the parts, but not for the time. He thinks he's being generous. Jamie is mad. Pat is mad. We're all mad. How can we fix this? What would we have done to address this proactively in a way that could have avoided this problem? I'm moving to go get a document that I accidentally threw away. It is the lease that I sketched out. So I went and I got a lease from Ag Lease 101, and I got your typical cash rent livestock lease. It says in there that the landowner is obligated to make repairs. Okay, fine, I can't find my document. I'll just tell you. To make repairs that are, I'm forgetting. Yeah, I hate when this happens. Too many papers. Let me see. What I'll tell you is that it's uncertain. It uses some language which sounds on its face to be perfectly reasonable until you ask yourself, does that include the well pump or does it not? You know, something like, well, it's fundamental to the operation of the premises. Is a well pump fundamental to the operation of the premises? Don't know. What do you do about that? You're just a person who's, you know, trying to develop this perfectly reasonable lease template for your purposes. What you do is you can literally take the piece of paper. You don't have to edit it in Word, and you can take a pen and you make a notation on the lease that says the well pump is considered a fundamental repair for this property, or you use whatever the language is that clause has said. You know, the well pump is considered fundamental. Therefore, the landowner has to pay for it. But you can't stop there. My story here is meant to show you, okay, great, the landowner has to pay for it. What if he doesn't? How long does he have to repair it? Okay, great, he has 2 weeks. He doesn't do it. So what is Pat, the tenant, supposed to do then? Can he or she do it him or herself? Can they hire out to do it? Well, let's say they can hire out to do it. Who do they have to hire? Who are they not allowed to hire? Are they allowed to hire their relative? Because of course the assumption is, well, the relative is going to have some inflated rates because Pat's not paying. So, okay, we'd say something like, the landlord has 2 weeks to fix it. If the landlord fails to fix it within 2 weeks, then the tenant has the right to retain a professional at arm's length to make the repair. Arm's length means we're not friends. I pulled you out of the phone book, you know, to retain a professional to make the repair. Pat, or the tenant, then has the right to send the bill to the landowner. We can't stop there. What if the landowner doesn't pay and now the contractor is coming after Pat? You know, Pat called him out and had him fix the thing and now nobody's paying his bill. We have to go even further and say, if the landowner does not pay the bill, then Pat has the right to deduct the value of that repair from the next rent due. Now we're finally done. We have played out plan A, plan B, plan C, plan D. Keep asking yourself, what if we don't? What if we don't? What if more things go wrong? So this can be, you know, kind of a depressing game, but this is how you get to a really thorough conversation and a deep understanding of what your obligations are going to be for each other. So that's a lot to write down, but that's all you need to do. Just write it down. and be thorough. And you can even tack it on at the end of the piece of paper that you printed out. You can, send another email that specifies these things. Those things do qualify as writing, and we will get to that. So excuse me for not actually having that piece of paper. I'm going to assume your cameras are too small to see me anyways. The point is, you can do this. You can think these things through and you can write them in. Let me get to a few more advanced issues before we come to the bottom of the hour and we're back to your questions. The bottom of the half hour. I call this section Let's Indulge the Attorney because here's where I really tackle some annoying definitions. I save this for the end because I have made my points to you. I have made my points that you need conversation and that you are sufficient to handle a lot of the brainstorming and resolution that you need to develop a good relationship. I've also reminded you of when you really do need an attorney. So having covered all of that, let's get into some more technicalities. What is a lease? Is a lease a document? Is it different than a rental agreement? A lease is not either of those things. A lease is the right to use land that is owned by someone else. It is a right, and that is the fundamental characteristic of a lease. So, how is a lease different than something else? Legally speaking, we always have buckets and we have to cram everything into the right bucket. If you gave someone the right to be on your land, you extended them a lease. If you gave someone the mere permission to be on your property, you did not give them a lease, you gave them a license. My classic example here is, let's say you invite your sister and your nephew over for a birthday party. An attorney knows you gave them a license to come onto your property. You gave them permission. You invited them to a party. Now, if we didn't give them a right to be there and we didn't give them permission to be there, I'm going to guess they're a trespasser. They really shouldn't be there. So those are our basic boxes. The lease box is the one about rights. That right can be given verbally, or that right can be given in writing. That's the mode that you're delivering it and the mechanism you use to memorialize it, but it is not the right in and of itself. That right can be extended for 1 day, for 1 century, for longer than that. You can extend it in exchange for $1 or $1 million. In bold, a lease can be whatever you want it to be. It is a right. And you define entirely for yourself what the nature and the characteristics of that right are. You also want to make sure that you aren't creating a license when you don't intend to, or that as the agricultural producer, you are not accepting a license. The key difference between permission and a right is permission can be revoked at any time and is not legally protected. So if you accidentally extend a license, then that's a much different scenario. The good thing is you're not really doing, nobody writes license and nobody says I can revoke this at a moment's notice at any time. The only situation where that accident is made is if you are an agricultural producer who is accepting free rent. I highly recommend you do not accept free rent because you're at risk of creating a license. It's what we call consideration. There's no consideration, and you've got to have consideration to have gotten a right. So what this also means is all of these terms we throw around about leases, like a crop share lease or a fixed cash rate lease or fill in the blank. That's not a legal term. That's a shorthand phrase that we have used to try to characterize what people generally mean in that situation, but it's not legal. So you're going to be angling for some disappointment if you walk into an attorney's office and say, I'd like a crop share lease. You'll be like, okay, I'll Google that later. But basically, they still need to know what you want the lease to say. It is up to you what it says. But you work in the real world where people use these phrases and they don't care that they're not legal. And it's still worth us talking about. So even though I've given you that preface now that these are not legal terms, the world is your oyster, let's review what people normally mean when they talk about some specific characteristics of leases. we're going to talk about 3 different ways that we structure rental rates for a farmland lease: fixed cash rate, flexible cash rate, crop share. So fixed cash rate, this is an average. I'm going to move this. What happened to I am so sorry for the technical difficulties that are resulting today. I think at some point here I edited all these slides, and what happened to them? This is the wrong average rental rate. What we're talking about here, which is probably not a surprise to you, we're talking about something on the average of $180 for irrigated farmland in the West, something more like $30 to $50 for non-irrigated farmland in the inland West. California, Oregon, and Washington are going to be higher value, but for your New Mexico, Colorado, Montana types, that's a good range. That's your classic fixed cash rate at a market rental. When is this suitable? This is suitable for landowners that need steady, predictable income. This is suitable for landowners that want to avoid self-employment income and don't have any agricultural experience. This is very, arm's length, like, hey, let's just take, a plain old cash rate. It's suitable for producers that want a fixed, predictable rental expense as well and don't want any involvement by the landowner. But from a sustainability perspective, fixed cash rates have a problem. A fixed cash rate locks your producer into making money through one of 2 ways: reducing expenses or increasing revenues. That's not always good for your land as the landowner. If my only options are to reduce my expenses because I have no control over the marketing of my product, no control over what the market will pay for it, then all I can do is try to get by cheaper. Usually that means not making an investment in soil quality, not taking the time to gather the information that I might need to make more careful decisions about nutrients or stocking or things like that. So when we work with fixed cash rates, we're really limiting the ability of the producer to make more effective choices for their business over the long term. Does that mean it's bad? Not necessarily. Sometimes we need this. Sometimes we need this steady, predictable income, and producers themselves want a steady, predictable expense. But we have to acknowledge that we're putting pressure primarily on the producer to make a profit in some other way. Your flexible cash rate is an alternative that can help to alleviate some of that pressure. It can broaden profit mechanisms for the producer, which is attractive, of course, to the producer and to the landowner many times. We can say that the cash rate goes up and down according to gross revenue. So if what we're pondering for a sustainability initiative will decrease revenue, maybe because it decreases yield, then both of us will suffer. Then I as a producer, I wouldn't have to fret about how am I going to make that up elsewhere. So looking at gross revenue is a good option. Another example is 45 cents per pound of gain. If we're talking about animals, I make money because my animals put on weight. Your more profitable rangeland, more productive rangeland, we're going to have a better rate of gain. If we're doing something that's going to reduce that, we both share. This comes with some problems because it only works for producers that are comfortable tracking and sharing the data required to follow a flexible cash formula. That means I have to tell you my gross revenue. It means I have to tell you how much my animals are gaining. And I might not want to do that because I'm a business person who is proud of what I do. I'm worried you'll tell the neighbors, or, there's any number of reasons why I don't want to talk about that. So if you're looking at this and you're thinking, I want to use a flexible cash rate because I want to share in risk and reward here to an extent, and I want to make this comfortable for my producer, think about offering some confidentiality. Think about how you can assure the producer that you're not going to blab about this over coffee the next morning, that you're not going to make this publicly available. One of the elephants in the room I haven't brought up is that sometimes the person on the other side of the table is government. So we're not really in a position to, as producers, to have expectations. The leases take it or leave it. And that can be a problem. And many of these leases are publicly available, so other people are going to read them. These are some limitations that can be really difficult to manage as a producer and as someone who's concerned about sustainability on lands that are publicly owned. I don't necessarily have golden keys to unlock that. We have creativity, but we need to wait until the other side is willing to engage in a more creative process. Lastly, we have something called a share rate. A share rate is when landowner and producer go in together and really, they're basically forming a kind of a partnership where they're splitting expenses and splitting revenues. When we're doing this, if we're splitting expenses and splitting revenues, we are deeply involved together in whatever this production venture is. Why would we do this? This is usually happening because the landowner wants self-employment income. Why do they want that? They are trying to build their Social Security income tax base for the most part, for their retirement. Some landowners want to manage the timing of income or want to be able to depreciate capital investments, so they need to have skin in the game in order to be able to do that. It works where the landowner does have a deep understanding of agricultural production. And so conversely, you need a producer that really wants to benefit from this. Maybe they want the mentorship. Maybe they want access to that capital funding, that the landowner is going to put in. But again, the producer usually has to be willing and able to provide detailed business documentation. This is exposing everything. This is, look, these are my profit and loss statements. This is how much I spend on XYZ. Here's how I decided to buy that thing. All of a sudden, everything is on the table, and these, this partnership takes on a whole nother level. That can get a little scary to some producers and feel like handing over a lot of control. But that's what it is, because this needs to be a legitimate, it needs to be legitimate self-employment for the landowner usually. So that's our motivation. There's no single correct answer for any piece of land or type of production or for any specific sustainability goal. These are very personal decisions, especially where we have a private landowner that is managing income, depreciation, things like that. It's very personal to them. Where we have more institutional partners that are, not operating on that like retirement-based level, we sometimes have more flexibility to talk about, flexible cash rates and things like that. So it all depends. I have some more details for you on cash-based rates and how to set them, and particularly how to achieve your sustainability goals when you're thinking about setting these things. Market rate. Oh, good. Here are my prices. Okay, market rate is what everybody falls to. Hey, what's the market rate? Let's go with that. And maybe we do that because we know we can go to the National Ag Statistics Service and we can get data. So yeah, here you go. I got Montana, Colorado, New Mexico. There's your irrigated and non-irrigated rates. But you know what it is. These are averages. Is this, Colorado, is this right outside of Boulder? Is this, on the Western Slope? That's going to make a big impact. And yeah, NASS data goes down to county level, but that still isn't going to tell you that what are the personal motivations of the people who came to these rates. Is this influenced by things like needing to earn self-employment income, or are these familial relationships where we're cutting a deal because it's the niece, it's the aunt or uncle? There's a lot going on here, and none of that means this is the right rate for you. It's like a house assessment. There's a lot of different ways to determine it. Certainly asking around is a good option. A landowner and a farmer or rancher in a similar position to you that are 2 states away is sometimes a better corollary than NASS data for your county, especially if you're non-typical in your county. So of course, ask around. Think about listening to some farm radio too. Those folks also rely on NASS data for a lot of this stuff, but a lot more discussion of the nuances of rental rates comes up and what sort of factors people are taking into account. You can pick up pretty quickly that farm insurance, crop insurance, livestock insurance plays a role in setting rental rates that might not be intuitive, but by giving farmers and ranchers a fallback, it helps them. I know if my crop is wiped out, I'm still going to be able to pay the rent because I have crop insurance. In particular, consider whether the producer is not able to buy insurance for his or her crop. Where that's the case, they probably are going to need some sort of discount on this because they don't have that revenue protected. So market rates are deceptively easy. And again, we have to emphasize that this puts pressure on the producer to make money in some other way. Cutting expenses or increasing yields. Not always what you want. I'm going to skip down to operator's cost because it's a good contrast. We can use the operator's cost to determine what is fair for a rental rate. The operator's cost uses the core assumption that the operator should pay what the capacity of the land and the market for the product can support. So you can tell this is more sensitive to the individual needs of that piece of land. If that land needs substantial improvement, remediation, needs some tender loving care for a while, then the rental rate can directly reflect that. The way we arrive at that is we're basically, we're using profit and loss statements from our producer. I took a small scale vegetable farmer here because our numbers are quite dismal a lot of times. So it helps to make my point. Your beginning small scale vegetable farmer is on average going to grow 6,000 per acre, and 20% of that is net. They might make $24,000 in a year, and that is not subtracting for the cost of their own labor, which if we value at $15 an hour, well, they only lost $7,000. So a lot of your smaller producers that are really in innovative markets are going to have very little capacity to pay. We talked about how we don't want to make it free because we don't want a license here. But sometimes when we use the operator's cost model, we come down to a rental rate of 0. There is no capacity. So you're expecting that the producer is not going to pay themselves in order to make this work. Sometimes that's a totally fair assumption. Small business owners of all types often do not make money, do not pay themselves for a while. But we should acknowledge that that might be what's happening. We can look at operators' costs for a more mature operation where we are grossing 20,000 per acre, 40% of which is net. All of a sudden, we're closing the end of the year with money. Okay, good. Now we can have a reasonable conversation about what's our operator's cost and what's a fair expectation for the percentage that should go to rent. You can Google these things. What is a fair expectation of what should go to rent? It is discussed in your rancher's agricultural leasing handbook in particular. But again, you're going to need a good conversation to sustain this. The farmer's going to want to say, well, look, I need to make an investment in, XYZ, or, you're not, especially like water, we may need some significant irrigation upgrades. You need to give me a credit for that next year. Because it's going to kill my profit. So it leads to a lot of additional conversations, but it is a much better way sometimes to accommodate sustainability. I want to contrast that to landowners' cost. This is a third way of arriving at what a rental rate should be. This core assumption is that landowners should make a profit from ownership that is comparable to what they might have received had they invested the money elsewhere. This doesn't really have a lot to do with sustainability, but this is certainly a core assumption and value that we tend to have as Americans, that we need a return on our investment. Sometimes when we are working with large-scale landowners that are treating this as an incentive or as an investment, we need to pay attention to this. There are formulas that we can use: property taxes, maintenance. We get to a total. We add in a return rate that we've agreed upon is fair, and we divide it by the number of acres. There you go. Rental rate. It might come out higher or lower than market cost. It really depends. So what is a landowner or a farmer to do? You have to understand your priorities. And you have to understand the relationship you're trying to create. Are you trying to create one that is focused on sustainability? Are you trying to create one that protects an investment? These aren't right or wrong. They're different. They have different values. And basically what you're going to do is you're going to run these numbers a few different ways. You're going to see what averages start to emerge, and then you're going to have your conversations. Why are these numbers coming out differently based on landowner's cost or operator's cost? What's going to happen into the future? There is no quick route to a relationship based on communication, trust, and mutual understanding. You knew that. Maybe you're married, you have kids. It's no different. It takes time. So I leave you with all of these considerations. Here's my slide with the exact title of this resource. Again, which is very technical and very, very money driven, is not themed around sustainability. So I have a few more things for you to help emphasize that sustainability perspective. I probably don't need to tell you guys how to think about sustainability on your land. What we do, of course, need to recognize is that every sustainability practice comes with increased costs or reduced yields, at least in the short term. And who bears those costs? I don't have an answer. I know you were waiting for it. So there is no answer except the one that you come up with for yourself. The quickest solution, sometimes the easiest solution, is to simply extend the lease term. Give the producer a chance to reap the rewards of sustainability. This is highly non-traditional, but like we said before, in response to someone who asked that terrific question, you can do it, and there is nothing standing in your way. Create a lease of 10 years, 20 years, 30 years. Look at our handbook for creating a long-term lease, for dealing with a couple of legal issues that will come up. In the short term, of course, what you can do is alleviate the costs of sustainability. Reimburse for those costs. Share those costs. Share in the downside risks. The downside risks means production might go down and expenses might go up, and your farmer isn't going to make money. Convert to, a percentage of gross revenue sort of formula, or operator's cost formula for a little while. That can help alleviate those things. It all comes down to conversations about money. Who's paying for what? All right. So what I'm leaving you with is not necessarily easy. How do we have hard conversations? Normally I would send you into some breakout rooms to have a deeper discussion on this, but we're going to have to move along from that, because I want to make sure that we get to some more questions before we go. But I want you to know there are models out there to help you have hard conversations, and this is one that I really like. If you want access to the slide afterwards, I can send it to you, or you can Google a compassionate communication model. It's a way to initiate a hard conversation. It's a formula for an opening statement that helps you have a hard conversation. Some of us need that. Some of us lay awake at night fretting about how we're going to start a conversation we don't want to have. So think about this formula. I'll leave it there for you for a minute while I take a drink. So on to my conclusion here. Bring on the joy, right? I said there'd be joy. Chances are good that you have some hard, awkward, or frustrating conversations ahead of you. No matter which side of this table you are on, I want you to know it's going to be worth it. Think back to a time in your life when you're the proverbial ostrich with your head in the sand. You don't want to talk about it. And it sits there in the back of your mind, festering and making you sad. Now think about the moment right after you have that conversation, when you experience the joy of release and freedom. You are let out of that cage that you were in, happy and giggling like a baby in a swing. You can tell I have kids. That joy is worth moving towards. It's worth pulling your head out of the sand so that you can experience that release and freedom of have that conversation. And it's no small thing. It is really, you are part of something big when you do that. When you write a lease or an operating agreement that is true to your farm and that reflects your values as a landowner, you are bucking the system. You're creating your own rules and playing on your own terms. And that's the way it should be for you. You don't need to wait for attorneys to tell you what to do or for default state laws to tell you how every farm should be run. You're in charge. It's not easy, but it's worth it. And it's the way that you can really live out your values for your land and your operation. So that's what I've got for you. It's not hard. It's worth it. Thank you so much for having this conversation with me. We have 5 more minutes for questions here. Then I have to go run and pick up my kids, and I will see you again tomorrow for any questions that have come up since then. And I will have some more resources at hand at that time, links and things that I can send you to help supplement what we have talked about today. So I encourage you to come if you are able. We got anything here, Taylor?
Right now we're getting a couple of thank yous. No questions so far. I would recommend if you have a question or you think of something, maybe write it down if we don't have time for it today, so you don't forget for tomorrow. But we'll see if any come in the next few minutes. Here's one from Jack. Any suggestions on where to find summaries of the lease laws in a state? Obviously, the state website will have them, but that's a lot to wade through. Any advice?
I'm really sad to say this, but no. This information, there is no market incentive to provide it to you. You are supposed to go to an attorney and pay for it. Nobody makes money when they give it to you for free. That's why Farm Commons exists, and we endeavor to fill that hole. And so we go out there and hit the pavement to write grants and get funding to do this research and make it available to you. That being said, it's very expensive for us to produce state-by-state indexes. We've been focused on achieving that for farm employment law, which is very complex and difficult. And we have not produced a comprehensive resource on state leasing laws either yet. If you know someone with a lot of money who would like to support this effort, send them my way.
Sounds good. I have someone asking what time tomorrow for the Q&A portion.
I think that's not quite set yet. And that's on me. I am in the middle of an email chain with our good people at Quivira to help set that time. So I got a little bit ahead of myself because I haven't responded with the exact time yet.
Okay. Let's see. Got a couple more thank yous.
Taylor, if I could just jump in, as soon as Rachel and I are able to figure out what time she's available to do the Q&A, we'll send out an email to everyone who's on the list for this workshop with the time and the Zoom link and any other resources.
Okay, great.
And I imagine since Rachel needs to run off to get her kids immediately after this, she'll need a little bit of time to go do that before we can get that email out, but should be able to get that out later this afternoon or evening, depending on what time zone you're located in.
Yeah, I'll be able to respond after I get back.
All right, we got another thank you, but no more questions.
Right.
So Rachel, if you would like to wrap up, I think it's a good time.
Yeah, absolutely. Well, thanks everybody. And I'll actually pass it back to our host. Do you have any surveys or anything else you want to announce? Otherwise, I'll let you close it.
Yeah, no, I don't think there's anything else on our end. So thank you so much, Rachel and Taylor. This was great. And thanks to everyone. And yeah, eventually we'll also have the recording and all that stuff available for folks as well.
Terrific. We'll see you all later then.
Bye, everybody.
Bye.